are recording today's webinar, and it will be available shortly after our webinar on our main page under the Knowledge Center, where you'll see a link for free webinars. You'll see that there are many webinars there. This one will be there probably within the next week. Our presenter today, many of you have worked with. Pam Nading is our unemployment claims consultant. She is awesome. I've worked with her for over 7 years now. She's specialized in unemployment claims and pseudotax management since 1978. I think she was maybe 2 years old at the time, so she's a genius. She's been with AlphaStaff since 2008, managing our unemployment claims and hearings. She also held roles previously as an HR generalist manager, and she's had 15 years in the human capital experience, successfully managing employee relations, recruitment, unemployment, and unemployment compensation control at a billion-dollar recruiting and flexible staffing company's national headquarters. So she has quite the experience to guide you through the topic today. And without further ado, welcome, Pam.
Thank you, Sandy, and welcome everyone, and thank you for joining today's webinar. I enjoy doing this. It's one of the things that I probably enjoy as much as I, believe it or not, enjoy hearings. And I say that because obviously I've spent most of my career working with unemployment compensation. For me, it was a niche area that I have found very interesting. And so, as Sandy said, I started when I was 2 years old, and I have stuck with it. Today, some of the things that I'd like to share with you is one, a general overview of unemployment compensation, what entitles a person to benefits in terms of benefit eligibility and disqualification, something relatively new with state and federal laws called compliance or employer compliance, critical documents. What do we need in order to win a case, or what documents is a state looking for whether we win or lose? Best practices, what is my expectation in working with you, and what can you count on from AlphaStaff when we receive a claim? And then, of course, there is an opportunity for questions. Now, toward the end of our webinar today, you will see some sample documents. These are available to you through AlphaSource. They're also part of this webinar outline that you will see on YouTube, and you can also request the packet in PDF so that you have those forms if for some reason you're not able to get them through AlphaSource. So without further ado, let's begin with a general overview. Unemployment actually came about in 1935 when Congress enacted the Social Security Act. The purpose was to provide temporary relief to individuals who lost their positions due to no fault of their own. And the first weekly benefit amount was right around $5, very, very minimal. Today, people are drawing $17,000, $18,000, $19,000 in unemployment benefits, depending on the state. Many states are not that high. And fortunately, there are laws that guide how much a person collects and the duration of the claim. Those particular laws are set by each state. Each state is allowed to identify their qualifying conditions, how much a person's entitled to draw, their benefit level, what denies a person unemployment or the disqualifying provisions, how they are going to determine who pays for it or their tax structure, and the one requirement is that they must comply with federal UI provisions. So how is unemployment financed? In most states, and I would say that two that I think of right away, Pennsylvania and New Jersey, it is solely employer financed through a tax paid on the first dollars earned by each employee. The state taxable wage base, or the SUTA taxable wage base, and that varies depending on the state. For example, in Florida, the state taxable wage base right now is $7,000, whereas in Georgia, it's $9,500. So that taxable wage base varies, and the rate of tax that an employer pays also varies based on the claims that have been lost or paid out, the size of the employer's payroll, and the overall general health of that particular state. Now, right now, we are blessed with having relatively low unemployment rates in most states. There are still some states that are high. Alaska, New Mexico are high. The District of Columbia is a little bit high. There are some northeastern states that are high. The Midwest generally has low unemployment rates. Florida generally has a low unemployment rate. And fortunately, because rates are tied to the overall rate of unemployment, the duration that a person is allowed to collect is also tied to the overall health of that state. For example, in Florida, a person is allowed now to only collect 12 weeks of unemployment benefits. Whereas, for example, in New Jersey, an individual receives 26. So what are some of the eligibility conditions that would afford a person unemployment? And let me start out by saying that it is never, ever our intent to prevent someone who is genuinely entitled to unemployment from collecting benefits. Our aim, however, is to make sure that we comply with state-required guidelines and that we provide honest, accurate information on a timely basis to the state. But what entitles a person to unemployment? The first thing the state looks at is whether or not the person is total or partially unemployed. We sometimes receive claims, received one just last week from a client in California, sent it in, said, we got this claim, this person's working for us, they're working part-time, we don't know why we got a claim on this person. An individual is entitled to apply for unemployment whether employed or not. By the way, there's a train going by, so if you can hear a train in the background, it really is a train. In this particular case, the individual that's working in California lost a full-time job. They are currently working on an as-needed basis for one of our clients, and based on unemployment law in the state of California, are entitled to apply, seek, and probably receive benefits while they're looking for suitable full-time work, or waiting, in this case, for suitable full-time work from their new employer. So unemployment may be determined initially based on the person's employment status. Are they able to work, physically, medically, able to work? An individual who is not able to work, who has had excessive absences due to legitimate illness where they're no longer able to come to work, and now is applied for unemployment benefits, may not be determined eligible if they're not able to work at this time. But by the same token, they may separate from you for a reason that has to do with a health condition, but at the time they apply, they're now able to work, or at the time they apply, they're able to do a job where they're able to work remotely, but perhaps that's not something that's afforded to them through your organization. They have to be available for suitable work. The word suitable is really key here. I may be available for work, but the state is going to look at whether or not that job that's being offered to me is consistent with what I've done in the past in terms of my where I live, in terms of what I'm being offered with regard to pay. They even consider whether or not there's opportunities for advancement, the duration or expectancy of the position. Is it permanent, theoretically, or temporary? And in order to collect benefits, they're also going to look at whether or not I'm actively seeking employment. Now that's done, in order to qualify for benefits, they are required on a biweekly basis to send in their search for work. It's done online. And fortunately, the states are much better now at tracking if an individual is actually looking for work. But by the same token, it's also very easy to log into someone's website, apply for a job, and put that on your form. So while it is checked, the state does a better job at checking that, it's still a requirement that may not prevent someone from collecting benefits. For the most part, those first issues the employer may have very limited involvement in because they deal directly with the claimant's status. They also look at, did I earn enough money, or did this individual earn enough money to qualify monetarily for unemployment benefits? Very easy to qualify. Usually the state is looking for a person to have earnings in at least 2 quarters, and for the earnings to be at least 1.5 times the highest quarter. The highest quarter may be $5,000, and that would be sufficient to qualify for unemployment. Now, you're not going to qualify for the maximum if that's all you earned, but you would qualify for unemployment benefits. And lastly, in order to be determined eligible for benefits, an individual has to separate from their last employer for work-connected reason that's considered beyond the person's control. An example of someone who might leave for a reason that's considered beyond the individual's control would be a layoff. If I was separated because my employer met with me and indicated that my position was being furloughed, or that at this time they simply don't have work for me, then that's a reason beyond my control and I'm legitimately entitled to benefits. AlphaStaff does their very best to process those claims as quickly as we can. Again, it's not our aim to prevent someone from collecting who's legitimately entitled, but to make sure that the information we provide to the state is accurate. So what denies a person unemployment benefits? What are considered the disqualifying conditions? To begin with, they look, and these relate most to the employer, voluntary resignations without good work-connected cause. Actually tomorrow, I do quite a few hearings. Tomorrow I'm participating in an unemployment hearing in a state. And the individual's reason for leaving the employer, he voluntarily resigned, submitted a resignation, and his reason for resigning was because he wanted to take vacation. The employer was shorthanded, said, "I'm really sorry, we can't afford you time off right now." And he resigned because he wanted to see the eclipse. And so he had very good personal cause for resigning. But the state looked at that and said, would a person in the same situation be willing to walk away from their livelihood given the same set of circumstances? And in this case, they ruled with the employer saying, no, it wasn't a good reason for resigning. The employer in this case has an employee handbook. In their employee handbook, it says that you have to request your vacation in advance. It says that the employer may or may not be able to approve that vacation depending on business needs. So the claimant had good personal cause for wanting to leave because he felt this was the opportunity of a lifetime, but related to his job, not good work-connected cause. Tomorrow, we believe that we'll probably win that case. But in order to win it, we will have a witness, we will have the employer's documentation, and we will present our case. What's another reason that might disqualify an individual from receiving unemployment? A discharge for work-related misconduct. And it truly does need to be work-related misconduct. You may hear of behavior that happens outside the office, but unless it's something where the employer has a morality clause that extends to behavior that might be viewed by the general public and cast light on the employer in a public way, for the most part, it needs to be work-connected cause. Something that's considered by most standards as willful or deliberate with such disregard of the employer's standard that the state says, you know, this person is just negligent in their performance of duties and therefore it's considered misconduct. The other thing the state looks for in identifying an issue where the employer is the moving party, where we've discharged, is whether or not it was isolated. You may have a policy that says first warnings are verbal, second warnings are written, third warning is a final written warning, and if anything else happens, termination will result. But if the first warning was for attendance and the second warning was for taking an unauthorized break, and quite honestly, if the third warning was because maybe they didn't follow through on a requirement that they had at work, and then the third warning was because they did something, they got involved in an altercation with a coworker, but it wasn't severe to warrant immediate dismissal, they're not related. And the state, therefore, probably would not view that case as being justified misconduct. So it's important that if you plan to dismiss, if you plan to identify the behavior that resulted in dismissal as work-connected misconduct, it cannot be isolated. Or if it is, Does the incident in and of itself warrant immediate dismissal? The other issue the state looks at in identifying whether it is work-connected misconduct is, was the employer harmed? Did the action that the claimant took injure the employer's reputation? Was this person, maybe this person worked in a call center, and in the case of the call center, or in the case of maybe a healthcare industry or in a school where you're required to have a certain ratio of employees on staff at all times, and you don't meet that ratio, it might cause the employer to be out of ratio in a school where kids are, and that would be against legal regulation related to that state. Or it may be a situation where in the call center, you're injuring your reputation with the company that you're servicing because you've committed to have so many employees answering their calls. So the state also wants to know, how was the employer harmed? Or it may be to the business directly. Did this person do something monetarily against the employer? Was there a theft involved where this person did not turn in funds that were due the company? Obviously, that's an area where we can identify harm to the employer. But what is key in all of these where you're dealing with work-related misconduct, where the employer is the moving party, is that the burden of proving your case falls on the employer. It's the old adage, innocent until proven guilty. To be honest, in almost all cases dealing with unemployment, the burden of proof falls on the employer. For example, an individual resigns. You're thinking, well, burden is on them, they quit. The claimant states to the examiner, well, I resigned, but they changed my job, and my supervisor was trying to get me fired. And she was very hard to work for. She treated me different than everyone else. And so finally, after going to her and discussing this with her and not getting anywhere, I felt I had no recourse but to look for other work, and so I resigned. Comments like that from the employee immediately switch the case and the burden of proving the case to the employer. So it's good to always consider the employer the party responsible for proving what occurred. Honestly, in many instances, whether it's done for nefarious reasons or it's simply a case of I see it from one perspective and the employee sees it from another, in most instances, the employer and employee do not see things from the same perspective. So it's important that we have the necessary evidence when we're putting our case out there to the state to show the actions taken by the employer were reasonable and prudent and for good cause. When a person does get disqualified, normally they're disqualified for a set period of time. In most instances, they're disqualified between 4 to 17 times the weekly benefit amount. The decision will read something like this. So-and-so was discharged. They'll cite why the person was discharged. Therefore, you are not entitled to unemployment benefits, and you will remain ineligible until you re-enter the labor market, earn 4 to 17 times the weekly benefit amount, and then re-qualify for benefits, separating from your new employer for a reason that is considered not disqualifying, like layoff. So if a person is denied benefits, it's somewhat hard to re-qualify. That said, the burden is looked at very serious by the state. In the state of Florida, for example, that 17 times the weekly benefit amount is accurate. In Florida, when a person is denied benefits, they're denied benefits until they re-enter the market, earn 17 times the weekly benefit amount. Florida is $275, and then separate from the new employer for a non-disqualifying reason. Well, in Florida, you're only entitled to $3,300, so you're actually required in the state of Florida to earn more in wages from other employers and separate for a non-disqualifying reason than you're ever going to collect in unemployment in the first place. That said, the state is very inclined to offer benefits, to see it as a benefit. You know, everybody should get it. We do our very best, like I said, not to fight cases where people are genuinely entitled, but to make sure that the employer doesn't end up paying for claims that they shouldn't. In the next slide, I want to look at one of the areas that probably is most problematic for employers. Performance or poor performance versus work-connected misconduct. What is the state looking at? And on AlphaStaff's Notice of Employee Separation Form, and I would think that many of you are familiar with our documentation that we ask for or that we offer to all of our clients as part of our service. There is a separation code under the poor performance category called failed to meet expectations and/or quota. That's an ideal code for somebody who, say, worked in a sales position, had a set quota of what their target sales goal would be, tried their very best, didn't meet the expectation, and was let go. You might use that code, or you might use competency, tried to the very best of their ability. But what does the state look at when they're comparing poor performance and misconduct? One, was I able to do the job? Was it a case of genuine incompetence? I just couldn't do it. Or is it a case of I'm absolutely refusing? And maybe I'm passive in my refusal. Maybe I have a supervisor who says, hey, you know, I need that report by the end of the day. And I look at them and I say, uh-huh. And at the end of the day comes and the report isn't there. I didn't turn to them. I wasn't insubordinate to my supervisor and say, I'm not going to get that report done. But I didn't get it done. And I had in the past, and I didn't communicate like I should have. All of those things are the things the state look at in determining, is it misconduct or is it poor performance? Did I, as the employee, try to the very best of my ability to perform my duties? Or in the case of misconduct, was it a willful action of repeated neglect? Had I shown in the past that I could do this job adequately, and now for some reason or another, I'm choosing not to? Maybe I'm not meeting my performance goal because I'm coming to work late, or maybe I'm not meeting my performance goal because I'm on my cell phone when I shouldn't be. Maybe I'm spending time on my computer looking at pages that are unauthorized instead of focusing on my work. All of those are reasons where, as an employer, I would discourage you from using the code failed to meet expectation and/or quota. Those are really cases of work-connected misconduct. Spell out what the misconduct is. Tell us what the person did wrong. Identify the behavior, and hopefully they've gone through corrective counseling if it didn't warrant immediate dismissal, and identify exactly what occurred, because that is not poor performance. We have found now with most states that when we complete a claim, you know, the one claim you would think would be a simple claim would be, we reach out to you, you advise us, you know, we don't want to fight this claim. This was really a case of poor work performance. And the state writes us back and says, well, were they ever warned? And yeah, maybe they were warned. But the long and the short is that the employer has determined they don't want to fight it because it was a case in their mind of incompetence. We have to prove that too. The state looks at that as just as important. The federal government now requires that an employer, through employer compliance, identify accurately exactly what's occurred. In the next slide on employer compliance, what do we do if you have someone on your end and you'd like them to collect unemployment? Responding to an unemployment claim is no longer voluntary. We are required to submit a response. If we fail to submit a response, the employer can actually be penalized on future claims where we would hope that we have that right of protest. Employers are required, and we through AlphaStaff respond to your claims on your behalf with timely, accurate, adequate information. And if we fail to do so, we face penalty. So you may receive emails from me, or as our first line of defense, many of you have probably met Kay Ann Walker, who also works in the unemployment claims department, does an outstanding job And she will reach out to you and say, we've received a claim on so-and-so. Our records indicate that this person separated due to job abandonment. And in that email, you may get a very long questionnaire from us that says, oh, would you tell us what was the last day they worked? What were those days that they were scheduled to work that they didn't report to work? Did you ever hear from them again? All of these things are critical to us so that we can respond to that claim with timely, accurate, and very important, adequate information, or we face penalty. And how we communicate that information to the state in a timely manner is absolutely just as critical. What are some of the documents that we look at and hope that you've used before making the decision to dismiss someone? What I'd like to do is go over some of those documents that we consider critical, and then in this packet, you'll also see samples of those documents as well. And as we look over those documents, as you see the notice of employee separation form, and I'll touch on a few of the general reasons for separation. But as you look at those forms, if there are some specific reasons for separation that you'd like to discuss, feel free to send it to us in the chat. I'll try and touch on those, or if you have a specific question at the end, I'd be happy to answer that as well. Documents that support our case. These are documents, probably every claim we send in has a packet of paper that's anywhere from the 2 pages that the claim includes to the 30 pages that the employer provided so that we could justify the action taken by the employer. What are we including? Well, first we're looking and asking you for the employee handbook acknowledgement. Hopefully when the individual was hired, they were provided with a copy of the employer's handbook that identified what the employer's expectation was on the job. What are your policies regarding attendance? What am I to do if I'm going to be absent? Am I to call you? Am I to call my supervisor? Am I to send a text message? Do you not allow text messages? What are your policies? And when I have reviewed that and signed off at the time of hire that I've received it, that if I have any questions, I'll ask, and that I will abide by the policies, that becomes a critical document. Many times in hearings, I will have individuals that will say, I didn't know, or actually it goes like this. We have a case, we send in our documentation, either the claimant wins or the employer wins. One of the two parties disagrees and the case goes to a hearing. At the hearing, in many states, the state will send us all of the documents that are on file already. And what I typically see in the file coming from the claimant is, I was never warned. I didn't know that was the policy. I was so surprised when they fired me for it. I had no idea I could be fired for something like that. But what the claimant then sees coming from the employer in that same packet is the employee handbook acknowledgement, prior warnings that they signed indicating that they knew that they had violated a policy, and the employer's outlined expectation as well as consequence for future, should there be a future infraction. Those things allow those cases sometimes to be dismissed right away. It's not uncommon. In fact, I had one just last week, literally last week. I'm on a hearing, and this morning, as a matter of fact, I'm on a hearing for an employer, and the claimant indicated that she didn't resign. She never resigned, and that the employer fired her. Well, the claimant resigned by text message. The employer provided me with a copy of the text message. I sent it in as part of the employer's documentation. Our evidence was in the packet. The claimant got on the call for the hearing, but as soon as the employer got on the call, she heard her supervisor on the call with me, and she saw the employer's evidence. She disconnected from the call. The hearing went forward because the state had ruled against us, but we went forward with the employer's evidence unopposed. Having these documents can mean the difference, absolutely the difference between winning and losing. And it can also mean the difference between receiving a penalty for inaccurate information or adequate information. Particularly in the state of North Carolina, they look at an employer, will say, well, was the employer's response adequate? They'll request from us within 48 hours the employer's corrective counseling, employee handbook, acknowledgement, various forms that I'll touch on each one of these. If we write back and say the claimant was never warned, the state's going to take that into consideration. In some cases, they may even consider that inadequate. If the claimant says, well, yeah, I was warned, well, maybe the claimant's referring to verbal, or maybe the employer warned, but they're looking at the reason for separation as poor performance. It all has to fit together in a very accurate, adequate way, or we risk penalty. What are the other documents that are extremely critical? One is the Employee Disciplinary Action Form. In fact, you see it here on the screen. The Employee Disciplinary Action Form is an opportunity for you to meet with the employee and to identify that behavior that the employer considers not what it should be. Now, what's the purpose of a disciplinary action form? It's to make sure that the employee knows what the standard is, to afford them an opportunity to improve by identifying that behavior that the employer doesn't consider acceptable. Key things on this document is, one, obviously the employee's name, the date the action took place or the infraction took place, the employee's position, date of hire, who is administering this document. It may be their manager or it may be someone else that's signed down at the bottom. Is this in terms of disciplinary action type? Is this a verbal warning? Is this a written warning? Is this the final warning, or is this person being terminated? This document is critical for terminations as well. When you met with the person at the time of termination, they might not be willing to sign this, but I would still ask that you complete the document, that you have someone else present, that you show it to them when you conduct that termination meeting. Because it's not enough to have you tell me what occurred. We need it in writing. With dealing with the state, they want everything in writing. What was the nature of the offense? Attendance? Was it a conduct issue? Was the person insubordinate? Is it a case of performance? Again, think about the words performance. Is it poor performance? The state many times will look at that as a reason that affords a person benefits. So if you don't see it as poor work performance, if you identify it as deliberate unsatisfactory work performance, be careful as if you're picking that code. Maybe you want to choose other and you want to make, or conduct, or utilization of time, or failure to follow directions, and then identify the specifics. What's also extremely helpful on this document is that the very next section covers previous disciplinary action. So if this is the written warning or the final warning, I should see something written in numbers 1, 2, and possibly 3 that identify that this is not the first offense. It may very well be that this is the document that the claimant signed. So having this document signed also authenticates the incidents that happened prior as well. There's also an opportunity for the employer, or excuse me, for the employee to document their position as well, or to incorporate pages and include their side of the story. But it's key to have an employee disciplinary action form completed when it's necessary to warn someone. They need to know what's expected, and more importantly, they need to know what the consequence is. There's nothing more frustrating to an employer than to have a situation where you terminate someone for work-connected misconduct. The termination is very justified, and then to lose the unemployment claim after we've worked really hard together, partnering together, because we simply didn't have enough evidence. Perhaps the document wasn't signed by the manager, or maybe that manager is not there anymore and it wasn't witnessed by anyone. Or maybe they talked to the claimant about it, they talked to the employee about it, but nobody signed the bottom. Having those signatures is absolutely critical, and it is a key piece of documentation that we include in almost every case if it's a dismissal for misconduct. And in most cases, that final incident that cost the employee their job is not something that warrants immediate dismissal. It's been an ongoing problem that the employer communicated repeatedly. So the state wants to see our repeated counseling on that issue to show that the employer took the necessary steps to attempt to resolve before having no consequence but to let the individual go. Also included in the packet, and you can use a number of ways to document attendance, and I would say attendance is probably the most common reason for separation that I see. People don't get to work on time, or they're absent excessively for reasons that are not considered beyond their control. The employer warns, but doesn't necessarily do enough documentation. What is the state looking for if we're dealing with an attendance, a separation due to attendance? One, they're looking for, is there consistency with the employer's policy? If you have a policy that says that a person can be discharged for excessive unexcused attendance, then the state's going to look at, how did you identify it as excused or unexcused? What does the employer identify as excused? What does the employer identify as unexcused? Having that documented is critical. When this person, did they call in? Does your policy say that, yeah, it's going to still be considered unexcused if you don't provide us with a doctor's note? Okay, in some states that's acceptable. For example, state of Illinois. If an individual calls in, says, hey, I'm sick today, I'm not going to be in, the employer's going to say, thank you for letting us know. Do know that you're going to get points. And I'm thinking of a particular client that could lead to your dismissal if you continue this way. However, if you bring us medical documentation to substantiate your absence today, we will not issue points. So there's an opportunity for the employee to end up with 0 points for that particular absence. States are different. State of Florida, also the state of Georgia. If I call in and I say, I'm sorry, I can't come to work today, I'm not feeling well, and the employer says, look, we really need you here. We need you to be here. And you say, I'm sorry, I'm just not feeling well, I can't come in. And you say, well, we've talked about this in the past. I need to let you know that when I see you, we're probably going to need to discuss this further. And you issue corrective counseling. At some point, you documented well what's happened, but the final absence was due to alleged illness. This individual is going to be determined eligible for unemployment because illness is usually considered a situation beyond the employee's control. State looks at it and says, it's not their fault, they're sick. They'd probably be there if they could. Therefore, if you discharge on an absence that has to do with illness, the individual will be deemed eligible for unemployment benefits. When you're documenting attendance, you need to document, when did they call in? What time did they call in? Did they call in like they were supposed to, 2 hours before the start of their shift, or as soon as they possibly could? Who did they speak with? What did they tell you? What did you advise them? And was there any follow-up to that the next day when they came to work? All of that is critical if we're going to win a case that has to do with attendance. This is a copy of the employer's Notice of Employee Separation form. And on the very next page, this is a section I really want to talk about. Which is the body of that document. Now, I'll just talk briefly about what was at the top of the page. Top of the page, you're putting in information similar to the corrective counseling form we were just talking about. It's got the company's name, it's got the employee's name, where they worked, last 4 digits of their social security number, and it's also going to tell me 2 things that are very important. It's going to tell me their last day worked and the date they were terminated. And then you have this section in the middle where you can define why this person left your employ. And so in the middle, you have by headings, and please, if you can, only check 1. If you check off 3, because this person stole money and they were always clocking in when they weren't supposed to, and they were insubordinate when we confronted them about it, it makes it very hard for us without a clear write-up to understand what occurred. That's another reason why utilizing the disciplinary action form is so helpful to us, because you spell out exactly what occurred, and then this is the employer's document that identifies officially why this person was let go. Now, this document gets signed by the employer. We're not looking for the employee to sign this document. This is one that you fill out. If this person was discharged for work-connected misconduct, and remember we've talked about misconduct as being any willful, wanton disregard of the standard of behavior that an employer has the right to expect. So or of such reoccurrence that the employer would identify the employee as being culpable of the action as work-connected misconduct. So profanity, this initial category is very critical. Well, if you check off profanity, excessive use of profanity after warning, what I would like to know is exactly what did the person say? From the state's perspective, if it was bad enough to get them fired, then what did they say? I need to know exactly what the words were. Be sure that it's documented at the time the incident occurs. Another area, time theft. If an individual was clocking in before starting to work, then it's really important, maybe the person was clocking in remotely and wasn't actually on premise yet. I have had a few cases like that, and the employer found out about it, considered it time theft, and discharged the person. In support of that reason for separation, we would want to see, for example, maybe I'm going to have documentation that shows me the computer ID. I'm sorry, I couldn't think of the word I was thinking of. The computer ID that's going to identify which computer they logged in from. Was it the computer that they use at work all the time, or is it a remote computer? And they're going to show me also, or provide to us as well, this person's time and attendance for that week. All of these things are extremely important and help us in winning those cases. One of the things that I do want to say that's extremely helpful, and going through any one of these, but especially in the area of misconduct, if you warn someone and you advise them that if it happens again, you're going to be discharged, and then it happens again and you warn them again and you tell them they're going to be discharged, and then it happens again and you warn them again and you tell them that they're going to be discharged, the state is going to look at our case and say, when the claimant says, yeah, they said that, but I didn't think they'd really fire me, and say that there's credibility behind the claimant's statement. We do need to stand behind our word. And if we are saying that this action is severe enough to warrant immediate dismissal, then the next occurrence should warrant dismissal, or we should explain why that wasn't the action taken. We've determined in this case to afford the claimant one last opportunity, and the claimant has indicated a commitment to abide by this policy going forward. Everybody signs so that it's understood that the employer wasn't deviating from their policy, except for this opportunity that they've given the claimant due to circumstances that were very specific to this occurrence. The next document we have is the exit interview questionnaire. Now, quite a few of our clients use this. Some do, some don't. It may be done online. It may be a document that is initiated through HR that the supervisor never actually sees, and it's an opportunity for the company to really get a pulse on how are things in that department. How did this employee feel before I hire another one about the work environment? And it is not uncommon for me to see these forms filled out by employees who have identified the behavior, the workplace as being exceeded expectations, love their supervisor, and then apply for unemployment benefits when that new job that they were going for didn't work out, and say, well, the real reason I wouldn't look for a job in the first place was because the work environment was horrible and my supervisor was unfair. If we have a document like this on file, it completely eliminates that. An employer can't be held accountable for what they don't know. And if an employee at the time of termination this is the very first time that they're ever even communicating to you that they felt there was a problem, and they're not wanting you to do anything about it, they're just saying, yeah, we want you to know about it, that's helpful too. Helpful for you, for future hires, and also helpful for us if we're responding to an unemployment claim and showing that the employer did investigate the situation, or showing that the claimant did not identify any issues that they saw as being problematic. So what are some of the things that we would want to look at and perhaps identify today as practices that help us all? What I would identify as best practices. Probably what I've stressed more than anything else today is documentation. Whenever you identify a behavior with an employee that is not acceptable, document it immediately. Document it while it's fresh in your mind, and document what the standard is and what the consequence will be if the claimant fails to meet that expectation. Use objective language. Identify when you're writing out the corrective counseling report what occurred. Don't provide me with an opinion. This person just doesn't want to work. Well, maybe what you want to say is that this person was at work for 2 hours and was assigned to portion the meat for the subs today. When I came in, nothing had been done. Or, this person never closes right. But maybe what I meant to say was when I reported to work the next day, the coolers were not cleaned. The floors had not been mopped. All of these were duties that this person was accountable for. So use objective language that describes what occurred and doesn't give the opinion. The state wants to draw their own conclusion. What is another one that's key? Terminate weak performers who show little or no improvement as soon as possible. You know, in some states, for example, Illinois, 30 working days, if a person is separated within the first 30 working days, then the employer will likely not be held accountable for the claim. In Florida, 90 working days. It varies from state to state, and that is actually in here a page or two back. But there are also several states where once the person is on your employ, you're considered liable. And depending on how long they're with you, the employer will be charged proportionately based on the amount of wages earned while in your employ. So it's key that if you have people working for you, you're going to identify them as weak or employees that just simply aren't going to meet your minimum standard of performance. As soon as you can make that distinction, move forward, because you're accruing additional liability related to that claim. Again, in cases that involve work-connected misconduct, what's important to remember is that unemployment claims are final incident driven. When we put a case together, we begin with what was the straw that broke the camel's back scenario, and then we work backwards. Yes, this is what occurred with the final incident, but prior to that, this individual was warned on this date for a similar occurrence, and on this date for a similar occurrence. And here's their employee handbook acknowledgement, and here's the employer's policy. If an individual, say for example with attendance, maybe you have a great case of somebody that just can't get themselves up on time on Mondays. Maybe they're even very candid about it. When they call in, they say, look, I'm really sorry. I just have a hard time partying over the weekend, and I'm going to be late this morning. I'll be there shortly. And then you've warned them, you've done everything right. You come to the final incident, and the person says, I am really sorry. I cannot be there today. I think I've got the flu. I'm running a fever. I know I work with people who have immune systems that are compromised, and I really should not be there today. And you say, look, I'm sorry. We've talked about your tardiness. We've talked about your attendance. today is going to be your last day. It's also likely that you've bought yourself an unemployment claim as well. The final incident needs to be consistent with why the person has been warned, and always remember that the final incident is what determines whether or not they're going to be eligible for unemployment. Also, related to the final incident, how close to the date of the final incident did the employer make the decision to dismiss? Was this person doing something on Monday? You identified the behavior as being unacceptable, knew you were going to fire them, but you allowed them to work out the rest of the week because you needed them to. That type of reason for separation converts the case to an employer convenience. The incident wasn't strong enough to justify a dismissal, but not at that time. So it's very important that once you identify that behavior that warrants termination, that you also take action as soon as possible. Be consistent. Deal with all of your employees the same. Make sure that we're not going to end up in a situation where they're going to say the policy hasn't been enforced. In fact, I've had hearings on supervisors where the supervisor was discharged because it was found that the supervisor was not administering documentation, was not administering discipline in an equitable way uniformly to all the employees. So make sure that your supervisors are consistent with their documentation and treating all of your employees equitably and consistently in accordance with the policy. Allow resigning employees to work out their notice or pay out the notice period. Now, depending on the state, if you, for example, advise the employee, let's say I resign, I give you 2 weeks notice, and you say, hey, that's fine. You know, you don't really need to work out your 2 weeks. Today can be your last day. Thank you anyway. In some states, unless I had, as the employer, good cause for letting you go on that day, I've just converted a voluntary quit to a dismissal. Very important, therefore, that if you are not going to allow a person to work out their notice period, that you consider paying them for that notice period. If you don't, then it's very likely that in California or in New Jersey, for example, that you've just purchased an unemployment claim, and both are extremely expensive. In California, the maximum liability on an unemployment claim is $11,700. And New Jersey, it's approximately $17,000. So it's really important that if a person resigns, that you afford them that opportunity to work out their notice. Or if you say, no, that's not going to be necessary, it's because of what they were doing during the notice period that you made the decision to let them go, and you have now decided we are going to fight the claim on grounds constituting a dismissal for misconduct. What else is important? Provide timely, accurate, adequate information to the unemployment claims department. You know, we apologize up front for pestering you for details when we're responding to claims. It is not uncommon for a person to get laid off today or dismissed today, go online today, and for the claim to be in our inbox electronically tomorrow with a deadline. And the state may give us 20 days, but determined to adjudicate the claim in 7 or 10. Now, what does that mean? It means that we still have a right of protest, but once they've made the decision to award benefits, they don't reverse. We have to go to a hearing to hear our case, to have our case heard. So when we reach out to you and say, we're really sorry, we only have 24 hours, or we've got 48 hours, which is all the state gives us when they want additional information, we ask you to partner with us so that we can be timely, we can be accurate, and we can provide sufficient information for them to make the decision. Sufficient information, hopefully, so that we can win in cases where we should. But certainly sufficient information for them to make the decision. And if you're unsure about how to move forward in a case, an important best practice is to reach out to your AlphaStaff account manager, your HR account manager. Ask them for advice. Let them be your resource. Share with them the problem you're having with an employee and allow them to walk you through the options you have that you would want to consider in making the decision for the next step. As I mentioned, there are some special provisions in some states, and so I've documented them for you here. And if you are calling in today from one of these states, then this is information that you would benefit knowing. For example, I mentioned in Florida, if a person works for you 90 days or less, and at the time of hire, they were advised that their first 90 days are probationary, then should that person separate because of incompetence, and I do have to prove that it was incompetence, then the employer is not held liable for the claim. In Georgia, if they earn less than $3,300 or less than 8 times the weekly benefit amount, whatever their weekly benefit amount is. In Illinois, it's 30 working days. In Maine, 5 or fewer consecutive weeks. Missouri, only 28 days. North Carolina, if they're employed less than 100 days, and on the claim form, many times that option isn't there. It's one of those things that as an employer, we know to ask for and provide them with the necessary information. And in Virginia, less than 30 working days or less than 240 hours of employment. These are the special provisions where if you let someone go and you're looking at the notice of employee separation form, you would say that this person was let go during the probationary period. This is the section that we're actually referring to. So as we get to the close of our seminar today, and I see I'm going to go over, so I'm going to cover this next part quickly, and I apologize. What's AlphaStaff's role as we partner together? 1, your claims are going to come to us directly. We'll respond to your claim. We'll reach out to you for details. We'll provide the state with timely, accurate information. If we lose, we'll reach out to you and let you know, and ask for your opinion on whether or not we should move forward at a hearing. And if we decide to take that step together and attend an unemployment hearing, which are usually done by phone, then we will represent you at that hearing. I will represent you, or KN will represent you at that hearing. We're permitted by law. What do we look to from you to assist us as we partner together? 1, continue to utilize your HR manager. It means so much when you have contacted whoever your HR manager is. Maybe it's Sandy, maybe it's Sal, maybe it's Cindy, maybe it's Lori. There are a number of very qualified individuals out there that work with our accounts and can give you qualified HR advice on what to do with someone. Timely respond to our inquiries. Remember the best practices that we've gone over today. And at the time of separation, please send us that evidence. You know, if you send us all of the evidence at the time the person separates, you won't be in a situation a year later. I literally reached out to someone prior to going on this call today to say, I can't believe it. The state of New Jersey just ruled on a case and it's been a year. And do we have a witness? Do you still have that documentation? If you send it all to us at the time of separation, then you won't be in a situation where we don't have it when we need it. And an unemployment claim can go back 6 quarters, at least a year and a half, where the state is requesting information. These are contact information. Again, I'm Pam Nading, and I thank you today for allowing me to share with you some of the information that we experience and some of what we do on your behalf. KM Walker and I partner together to respond to your unemployment claims, and we do several thousand a year. You have our contact information. We encourage you to reach out to us directly anytime you have a question or need assistance, or to your HR manager, and they're only too happy to help. At this time, I'd like to offer it up to any questions that you might have, and I would be glad to assist in that respect.
If you have questions, you do have a Q&A tab, I believe, or it might say chat. You can type those in there. I've unmuted the group, so please go ahead and ask your questions.
I see a question here. It says, if a company needs to lay off workers that were hired within the past 90 days in Florida, is unemployment available to them? Yes. What the state is going to look at first is the reason for separation. Well, they were laid off due to lack of work, so the reason for separation is going to entitle them to benefits. The amount of benefits they receive will be determined by what they've had in earnings from prior employers. So if in their past they have sufficient earnings to qualify monetarily for unemployment, then they would qualify. In this case, if they filed for unemployment right away, then the employer would not be liable. In this case, we, as we partner together, would not be liable because we would not be in the period of time the state looks back at in determining which employers are going to pay for the claim. We would be looked at to determine their eligibility.
Okay, thank you, Pam. We also have a question. Should we try to get letters of resignation when possible?
Absolutely. I use them all the time. The case that I have coming up on the individual who quit because he wanted to watch the eclipse, voluntarily resigned and put it in writing, and it is absolutely part of my documentation. The case where the individual resigned because she just chose to resign and then said, nope, the employer fired her. We've used that. It's extremely helpful, especially if later they see it from a different perspective and feel that they really, maybe they were fired, or really maybe they quit and they had all these other good reasons. If they write you a warm, glowing resignation letter, thank you for being the most wonderful boss in the world, wish the company well, and then leave, it simply places us in a position where it's very clear how the final incident occurred and the employer was not the moving party.
That sounds great. Thank you. And Pam, how do you feel about when an employee offhandedly says, that's it, I quit, that a manager write down the statement, I hereby resign effective immediately, and ask the employee to sign that?
If they're willing to sign that, then absolutely. But I have had situations like that where the employee says, that's it, I quit. And the employee says, okay, fine. Well, thank you very much. And I enjoyed working with you. And you get to the unemployment claim and they say I was fired. Mm-hmm. And you say, no, I wasn't, I quit. The employer is saying they quit, and the claimant says, I did not quit. We had a conversation and I talked to them about the possibility of quitting, but I never told them what my last day would be. I never fully decided that I was resigning. They forced me out. If we don't have anything in writing and it comes down to their word against the employers, we will not satisfy the burden of proof because, again, the burden of proof falls on the employer. The claimant is believed unless the employer proves otherwise.
Gotcha. Any other questions at this time? And I don't see any, so I'm going to move along. Hopefully you've been seeing the slide that's on the screen now. If you do want a copy of the presentation and the related forms, the email address is hrsc@alphastaff.com. Also, please mark your calendars for next Thursday at 2 p.m. You may not be aware that almost 25,000 workplace injuries occur every day in the USA, and that costs about $1 billion per week for the direct workers' comp costs alone. That doesn't even include the cost involved when you're training a replacement or investigating or taking corrective measures, plus lost productivity, repairs, and costs that are associated with employee morale because of the situation, as well as absenteeism. So please, if you want to minimize yours and your employees' risk of workplace injuries, do not miss next week's webinar. And again, I thank you all for joining us and have a great day.